All right, so once again, hi. My name is Corey Strain. I'm an attorney with South Carolina Legal Services. So we're a nonprofit law firm. We help with civil legal issues. And today I'm going to be going over the CDC's moratorium on evictions and how to use that, and then some issues that might arise related to that. At the very end, we'll also have some organizations you might be able to reach out to for some possible rental assistance, because that is pretty important both in using the CDC moratorium and in solving any of the housing issues which are arising out of the COVID-19 pandemic and issues from it. Because this is a moratorium, but it is temporary. So eventually you need to make plans to either get current and solve those problems, or else it's still going to be an issue when the moratorium does end. And it's currently only set to last until the end of this month. So it will expire on January 31st, 2021, unless it is extended a second time. So a little bit about South Carolina Legal Services. We're a nonprofit law firm. We help people with civil legal issues who can't afford private attorneys. So typically our services are income-based. We can usually help people up to 200% federal poverty level. That's our normal maximum guideline, but we do have some grants where we can go beyond that. So if you are facing an eviction issue currently, or you have other civil legal issues, you can apply for our services. You'll have to do an intake, make sure you qualify, and then we can see if we can provide more help or assistance in that issue. And I will get through the application information near the end as well. One second, now the PowerPoint's not going to go forward. Okay, and I'm going to turn off my my camera while I'm going through the presentation, just so it's easier to see. And there's some copies of both the form itself and a little bit more information about it, which could be kind of hard to see. So that's why I'm going to stop the video while I'm going. So a little bit about the eviction moratorium. It started after the CARES Act expired. The CARES Act temporarily halted evictions for households that qualified based on usually, the mortgage status, or if they had some kind of subsidy. There was a pause on evictions that started back in March. However, that eventually ran out under that act, and there was a gap where people were still having housing issues, and it was causing a crisis where a lot of people were going to be without housing, which was obviously bad because it causes a large amount of homelessness and is really unstable for the economy and people's lives. And it also was bad because it was going to cause even bigger spike in COVID cases. So in order to prevent those issues, there was an executive order where the CDC looked into the issue. And out of that, they came out with an order in September, which created the new eviction moratorium. So that was originally issued in September and was only set to last until the end of 2020. However, it was extended as part of the Consolidated Appropriation Acts, the new stimulus bill, which has currently pushed it out till January 31st. And at the end of January, it will expire again unless it is extended. Now, what it does is if you meet the qualifications, and these are really going to be set out in a declaration, you have to go through a declaration. The CDC created a template. It's best to go ahead and use that. However, it's not technically required. You just have to certify all the things that are listed in the declaration as being true. So your qualifications are going to be the points listed there. The main issue is going to be, in order for this eviction moratorium to apply, it's got to be a qualifying eviction. And it's very clear when the only issue is non-payment of rent when due or demanded. The CDC declaration does apply. So throughout the effective period, if you meet all the other requirements and you fill out the form and then deliver it to your landlord, they shouldn't go forward with any eviction past that point. You can do it before an eviction's filed, and they hopefully will not file at all. Or if there's already been one filed, you can still use the declaration to put a pause on that. You just have to go through some extra steps since there's already a case pending, and you have to notify the court in those cases. But in order to qualify, you first have to make sure you've used all best efforts, which just means you have to go out and try to find any rental assistance or alternative housing that's available. If you send in applications, that will be enough. Most courts aren't going to go into the details about your attempts, but do make some effort, at least reach out and apply for a few places to see if you can get rental assistance. You also do have an income requirement. So in order to qualify for this moratorium and to do the declaration, you should expect to have no more than $99,000 in annual income if you're filing your taxes by yourself. And if you're filing joint tax returns, you should not have over $198,000 for the year. And that'll be the 2020 tax year. So when you're doing those filings, you should expect less than those numbers. Additionally, you have to be unable to pay your full rent or housing payments in order to use the declaration in the moratorium. I mean, obviously, if you have the money and you can't afford to pay it, you do still have to pay it, and this will not help you because you're able to pay. So you have to have some loss in wages or a loss in hours or have been unemployed, or you had some high out-of-pocket medical expenses related to COVID. If any of those things are true, then you can go forward as long as you meet the other requirements, you do qualify. The next requirement is you still have to make your best efforts to make payments to your landlord. So you have to pay what you can as timely as you can, but that is taking into consideration your non-discretionary expenses. So other expenses, utilities, food, bills you have to pay, those are taken into consideration. And if you're completely unemployed at the moment and you can't make payments, that's fine. But if you are employed, you just had a loss or you fell behind and you can't pay the full balance, you do have to pay what you can. Additionally, you have to not have alternative housing available. So if you have another place you can move into that wouldn't force you to live with someone else, like increase the household members, move in with a family member, something like that, where you're then forced to live in close quarters with someone else, or you would be homeless. If those are your only options, then you still qualify. But if you, for instance, are renting, but you own another home that you could move into, no one's currently using, like you have heirs property, then technically you wouldn't qualify because you already have a housing option and you should just go ahead and move there and use that. It's not too common, but it can happen. I've seen some people that wouldn't qualify for that reason. But usually the main ones are going to be you have the loss in income, so you're unable to pay your full rent, you fell behind. The next ones aren't really requirements, they're just statements you have to understand. It's very important to understand this moratorium is a delay in evictions. So when you meet all those other requirements, you sign this form, you deliver it to your landlord, they're not supposed to go forward and try to evict you for non-payment of rent. However, you're still responsible for rental payments and any other obligations you have under your lease agreements. So you are still charged rent, you still build up those balances. You also need to understand that they can still charge late fees and penalties that are under your lease agreements, and those will be charged anytime you're not making those full payments according to your agreement. You really need to look at the lease to see what the late fees and penalties would be. Those are usually laid out in there. Those will still occur. Those will increase your balance. And when the moratorium ends, you'll still be responsible for either paying all of the rent payments that you have not paid at that time, including fees that are allowed under the lease agreement. And if you do not do so, then your landlord can proceed with an eviction at that time, or they can resume an eviction if they filed one before you use the declaration to pause it. Additionally, you have to follow all your other obligations under the lease. So if you're violating a condition of your lease, for instance, let's say you had someone move in with you who wasn't listed on your lease, they're not an occupant, and you didn't get the proper approval from your landlord, that's a lease violation, and they could still file an eviction for that reason as long as they go through the process required by law. For most other violations, they would have to send you a written notice, and if you don't cure the issue within 14 days of the written notice, then they can go ahead and file an eviction. It's not for non-payment at that point, it's for a lease violation, which is not protected. The one that is a little more unclear is if your lease term has expired. So normally if your lease is expired, you had a term lease that ran out, or you've always had a month-to-month lease, your landlord can proceed with an eviction by sending a notice. They're supposed to send a notice, and if it's a month-to-month lease or an expired term lease, which then usually becomes month-to-month, they send a 30-day notice to you telling you that they're not renewing the lease, and after 30 days you have to move out. So if they do that, then they can file for end of lease term. And there's kind of a split on how that's handled. Early on, it was a little unclear, but unfortunately, most magistrates are now leaning towards the position that end of lease term is not protected by the CDC declaration, because they're considering it as essentially a term of the lease, like an obligation. So it's not for non-payment at that point. It's something they would have been allowed to do regardless of your financial situation with COVID. Now, you could potentially make an argument that it still applies if they're not really evicting you because the end of the lease term, but it's for non-payment. That's their intention, and they're just trying to use that as an excuse to get around it. But it's not clear, so it's up to the magistrate at that point how they're going to rule, and it would probably come down to what kind of communications you've had with the landlord leading up to an eviction being filed. If they make it clear that they're really evicting you because they want the rent and you're behind, and they say that, especially if they say it in the notice they send you, that they're evicting you for non-payment of rent, there's an argument you could make to the judge, Your Honor, this is really a non-payment case. This is clearly covered under the CDC declaration. It's not an end of lease term case. That's not why they're filing it. They're doing this to get around the declaration. Unfortunately, that will depend on the magistrate. It's not clearly stated in the CDC's order, and they haven't really clearly answered that question after the order was released in September. They kind of released a FAQ or a guide after the order was released, but it's not binding. So it doesn't really have any controlling authority over the law and how courts are to handle it. And it kind of created the inference that it would not stop end of lease terms. So that's why more of the magistrates were leaning towards not including that. And to the left here, this is actually the form template that was released after they extended it for the end of January. So you can find that on the CDC's website. The link at the bottom of the page should go directly to the page where you have links to this form in a PDF format. And also you can get a copy of the order if you want to read it in its entirety. Okay, so in order to use that declaration, you have to go through it, make sure you meet all the requirements, and every adult in the household should sign a declaration. And once you have completed it and signed it, you must then deliver a copy of it to your landlord. And at that point, they shouldn't go forward with the eviction process. Now, if they've already filed an eviction against you and you're doing the declaration in response to that, you already have a court case, so you should notify the court as well after you've given a copy to your landlord. And how they handle that will unfortunately vary from county to county. Some counties will go ahead and put your case on hold once they've been informed the landlord was given a copy and you give the court a copy of the declaration itself. Other courts will want some confirmation from the landlord, so they might call and ask them or wait until they confirm they received it, and then they'll put it on hold. And if they can't do that, some of those counties will then go ahead and schedule your hearing date, which is very important. If you get notice, even if you've done a declaration beforehand, if you're served with an eviction, that will tell you you have to request a hearing. And most counties, they don't go ahead and set a date. They send you the rule to vacate or show cause, and it tells you in there that you have 10 days to request a hearing. And it gives you the information for the court. You need to contact that court within the 10 days and request the hearing. Because even if you did the declaration, if you don't request that hearing, they're not going to know. And they're going to go through the process. If you don't request in the 10 days, they're going to then grant the eviction based on the application. And you'll get what's called a writ of ejectment. That's the form that actually puts you on notice the eviction has been granted. And it only gives you 24 hours, and then they can have you and your property removed. So you don't have a lot of time to contact the court, let them know you had already done a declaration, and stop that process if you don't request the hearing. It's better to go ahead and request the hearing and then tell the court that you've done the declaration first. And if you have other issues or they're trying to argue the declaration doesn't apply to your case, then you have time, you can prepare for that. And when you request the hearing, I don't recommend doing it the first day you get served with your eviction paperwork. You have 10 days to request it if you're actually served in person by the court staff. So it's usually better to wait a few days, maybe closer to day 8 to request your hearing, because they try to schedule them fairly quickly after they're requested. Currently, it might be a little bit more delays because they're not having in-person hearings right now. So all the courts have to deal with that. They either have to set up remote hearings where you have to be able to join an online service like Zoom or WebEx. They have different programs they use, or you have to call into the court and participate without actually being there. They're all trying to handle that in their own way, so there's not a clear process for every county. How it's going to work, that might give you some delays, but normally they will schedule these as close to 5 business days out from your request as possible. Sometimes they will schedule it sooner than 5 business days. Now, they're not supposed to. Due process does say they're supposed to give you 5 business days from the date you request it. And the reason for that is you have the right to request a jury trial, and you have to do that 5 business days before your hearing. So you can't exercise that right unless they give you at least that much time. Now, some courts won't give you the 5 business days, and the reason they do that kind of varies. Some of them, I guess, are just trying in a hurry. They're trying to get through the docket as quick as possible because the volume of cases they have, or the clerk who is talking to you when you're requesting a hearing might ask you if you're okay with having the hearing set sooner. If you agree to it, then their position should be that you waive the 5 business days. So that can be an issue. It doesn't happen with all counties, but some courts do that. And if you don't, request, no, I'm supposed to get this 5 business days out, they will schedule it sooner. And that's why it's important to kind of not jump on day one, because you might only have 1 or 2 days before a hearing. And if you don't get everything together and present your defense, you could be getting that writ of ejectment very quickly after you get served the eviction, where you should have almost 15 days if you go through the full process you have. You wait near the end of the 10 days, you request your hearing, you get your 5 business days. And between all that, that gives you more time to do a declaration and deliver it if you need it. Or if you're having issues where your landlord's arguing it doesn't apply to you, you have time to apply for assistance or find an attorney to assist you with your case. So try not to jump the gun on that. Make sure you do take advantage of the time you are given. Additionally, if you're not actually served in person, that's not when you're served. Your 10 days doesn't actually start. Sometimes they will go out and attempt to serve you, but no one is present, no adult or a minor child old enough to be served. No one answers at all. Then what they do is they leave a copy of the eviction paperwork on your door. That doesn't mean you're served at that point. What they should do is they try to serve you once. If they're unable to serve you that day, the court staff will notify the clerk, and they will try again at least 48 hours later, and they should do it at a different time of day. If they don't serve you the second time, you're still not served. They go out, they'll leave a copy, let you know when they attempted to serve it, and they'll tell the court that they were not able to serve you. At that point, the clerk should mail you a copy of the eviction paperwork, and there will be a letter which has a date on it when they mail you that. You have additional time when that happens because you get 21 days from the date on that letter to request your hearing. That's if you don't contact the court right away. There is a caveat where essentially they're giving you 11 extra days before your 10 days start, only if you do not contact the court about your hearing within that first 11 days. If you contact them and they are notified that you received the letter the day you get it, they will start your 10 days from that day because you called them within the first 11 days. Some of them will explain that in the letter, but not all of them do. So that's kind of something you have to be aware of. If you're served by mail, you have 21 days from the date on the letter. Do not miss that deadline, or else they might grant a writ and you have to rush your case to put a stop to it. And even if you did miss your hearing, you might still be able to stop the case using the declaration. It's a lot harder, and it's going to depend on the court, because typically if you do not request a hearing on these evictions, you have waived your rights to challenge the allegations your landlord has made. Normally, if you don't participate in the initial hearings, request a hearing, file an answer when you receive a summons, those things typically result in you being declared in default in most cases. And when you are in default, you have waived your right to then challenge what happens on appeal because you didn't participate in your initial case. So that can be a big issue, but technically the declaration says the landlord should not go forward with an eviction once they're served it. So some counties will work around that, where even if a writ's been issued and you were served it, if you do the declaration and you notify the court that you've done it, you've delivered it to the landlord, they'll pull back the writ. They won't enforce it. They'll put a pause on it. But it could still cause issues after the declaration expires because you might have waived your ability to challenge anything else the landlord has alleged, like the actual amount you owe. They'll put an amount in the form, how much you're behind. You might have waived your ability to challenge that you were behind that much at the time of the filing if you don't request your hearing. So make sure you do pay attention to the deadlines. It's very important you do not miss them, but you don't need to do them immediately as well, because then you're just giving up that additional time you have. Pay attention to the deadline and the notices you receive and make sure you follow those. That's the most important thing. Okay, so these are some problems that will happen, and I've kind of talked about some of these or alluded to them already. The moratorium, the declaration, does not stop all evictions. As I was saying earlier, it does not apply to lease violations. It's definitely going to apply to failure to pay rent, but if you made some other lease violation, you have unauthorized guests, you have pets that aren't allowed, you've had criminal activity you've conducted or you've allowed a guest to do on the premises, or you've done something that it puts the property or the residents in danger for a health and safety issue. Those are things they can still file. The declaration is not going to stop those evictions. The CDC order does not apply. End of lease term is a little more unclear. Like I said, most courts are leaning towards it does not stop those. But if it's really about non-payment, you might be able to get around that. The other problem with the moratorium and the declaration is it's a limited document. It's just putting a pause on these eviction processes. It's giving you time to either get money together and pay all of your back rent and fees, or to make plans so you can avoid situations where you're facing homelessness or situations where you're forced to live with other people in close proximity, which can result in an increase in the spread of COVID cases and endanger everyone's health and safety. So it doesn't solve the underlying problems. You're still going to need to seek rental assistance or some kind of payment plan, put something together to get caught up on any rent and fees that are owed in order to keep that housing, or else you'll have to make other arrangements and you'll move, and your landlords can then file a case for that back rent if they really want to try to collect it. But that's a separate issue than getting you evicted. Evictions themselves do not give the landlord the right to get a judgment against you saying they are owed money. They can do them together, but they typically don't, because that's a different case, and you get 30 days to file an answer when they file a complaint saying you owe them money. It takes longer. So most either don't file for the back rent, because if you're not paying, they assume they're not going to collect on it. It's not worth their time and money to pay an attorney and try to prove that. Or they just want to do the eviction first, and they'll do that later if they think they can collect, because they want the eviction. It's a quicker process. And if they file separately, it gives them more time to collect and then get you out sooner. Another problem with the declaration is they can challenge the truthfulness of the things you're saying in that declaration, or that it applies in court. That's kind of up to the courts if they want to hold hearings on that to see if you actually did fall behind on rent or you're unable to pay. Your landlord can try to challenge that in court and argue that that's not true, that you can pay the rent and you're choosing not to for other reasons. Like sometimes people will withhold rent because they want the landlord to make repairs. You can't just do that on your own in South Carolina. You're not entitled to withhold the rent. And in fact, you wouldn't even be able to use the failure of the landlord to make repairs as a defense for non-payment of rent if you had not gone through the proper process, which is sending notice to your landlord of the repairs that need to be made and giving them written notice of all those problems and 14 days to cure those problems, start the repairs. Or if it takes more than 14 days to fix it, you have to give them more time. If you haven't done those written notices, you cannot use those lack of repairs as a defense for non-payment. Unfortunately, that is in the Landlord-Tenant Act. And sometimes people aren't aware of that. They withhold the rent because they want the landlord to make the repairs, and then suddenly they're faced with an eviction for being late on rent. And before this moratorium applied, being late on rent alone would be enough for the landlord to go forward with an eviction. They have to have proper notices in either your lease agreement, or they'll send you a written notice at one point that tells you if you're 5 days late on your rent, they can start the eviction process. Most of them will go ahead and have that in the lease language as a paragraph in there. But if they don't, they just have to send you that notice once throughout your tenancy. They don't have to send it each time. If they've done that, then they can go and file an eviction once you're 5 days late, or 5 days after they send the notice, if they didn't have it in the lease or send it before. And even if you can pay at that time, if they want to, normally they would still be able to get the eviction because you were late. The law lets them go ahead and evict if you're being late on the rent. You can offer to pay the balance at the time, and a judge might ask them or try to encourage them to accept that. But ultimately, if they insist they want the eviction, they should be granted that. Fortunately, the moratorium stops that and it gives you more time. It's not specifically stated in there that if you pay the full back balance within the moratorium period, you're fine. But it is implied. So if you're able to get your back rent caught up before this moratorium expires, your landlord really shouldn't go forward. And if they still are trying to evict you, if you get them completely current, including your late fees, before the end of the moratorium, I would encourage you to seek legal assistance, apply for assistance with our office, or seek another attorney who can help argue that the landlord was paid. You are not late after the expiration of the CDC order, and because of that, they shouldn't be allowed to go forward with that process. But that's only going to help if you were able to get caught up before this expires. If you still owe a balance at the end of the CDC declaration's effective period, they're going to be able to go forward, and if they really want to then have you evicted, they will get an eviction for failure to pay rent on time. So like I said, that's kind of an issue, and that's why it's important to still make other plans where you're coming up with an agreement where you do a payment plan. You get rental assistance from an agency, and there should be more funding coming out for that as part of this extension of the CDC declaration. So even if you've been denied before, I would encourage you to keep applying, look for new programs, or see if ones you previously reached out to have received more money and might be able to assist you when you were previously turned down, because that's going to be necessary to solve the rent issue in the long run, while this moratorium and declaration is really just a stopgap. It gives you time to put those plans into place and come up with some solution. Another problem with this is when you're signing these declarations, you need to make sure everything you're signing in the declaration is true and does apply to you, because when you're signing it, you're doing it under the penalty of perjury. So if you sign it and something that's stated in the declaration is not true, for instance, you didn't have a loss in wages, hours, or an extraordinary out-of-pocket medical expense, or you're able to pay your rent, you just chose not to, and they prove that, you could be held liable for having committed perjury. And if you commit perjury on a form under the laws, it's a misdemeanor. So that can result in a fine up to $100, and you can get 6 months in jail, but it can be much longer and a higher fine if you do it in court. So at that point, it can actually be a felony to commit perjury in court. And that will happen if you went to court and testified, yes, the declaration applied to you, told the judge all those things were true, and ends up something isn't. So it's important just to be honest, make sure it does apply to you, and then you can use it and review it before you sign it or try to use it. That way you avoid the risk of perjury. So this is a list of some agencies and the surrounding areas you might be able to reach out to. I'm not sure all of these still have funds available. If so, that's great. Some of them might have run out because we came up with this list a month or two ago, so it's not been updated regularly. And additionally, there's been more funds coming in, so some of these might have run out and have received additional funds. Unfortunately, I'm just not been able to keep track of that accurately. So we were putting this resource list out here. Go ahead and take down the information, make sure they cover your area. And I would encourage anyone who still owes rent to go ahead and apply to any of those within your area, see if they still have money or if they can refer you to another organization that does, if they are in fact out or they're not able to assist you with your rent. One, that's a requirement under the declaration, and two, it just solves the long-term problem and helps you get in a position where when this finally does end, you're still going to have stable housing and not have to worry about facing homelessness or, living with someone else and finding new housing opportunities. And we will try to publish this. I have to get permission to make sure I'm going to be able to publish it and share it, but I am recording the presentation currently, and assuming we get that cleared with our executive director, we will try to publish this, share it with our partners at the library, as well as our own website, our YouTube page, and hopefully our Facebook page as well. But I encourage anyone to try to write down what you can now. or if you have questions about these agencies, feel free to follow up with us and we'll try to send that out if we're not able to publish the recording itself. Okay, so once again, if you need assistance, if you've already received an eviction, you're currently in that process and you would like to apply for services, if you think you'd qualify for South Carolina legal services, you can apply for our services by going to the website listed there. They have an online application process. So that's going to be https://www.sclegal.org. And you'll see a banner at the top which says apply now. You can click that and it'll go through the application process. Or you can apply by calling the 1-800 number listed there, 1-888-346-5592. That number can be busy, so if you don't get through the first time, just keep calling it until you get through. The number is open Monday through Thursday, 9 a.m. to 6 p.m. And when you call there, when you get through, they'll make sure you qualify, take down your information, do the application, and send it to the county or the office that would represent you based on where you live. Most people in this presentation, it should be to our Charleston office, and then an attorney will reach out to you once they receive that intake to get more information, see what assistance they can provide, and help you with your case. Now, if you've already been served with an eviction, so your deadline's starting, you have that 10 days to request a hearing, or you already have a hearing date, or even worse, if you've received a writ of ejectment, so you only have 24 hours before they remove you, then instead of calling or applying online, go ahead and call the local office, which should be our Charleston office, and tell them that you have that emergency. And the number for that office is going to be 843-720-2044, and then hit 0 and speak with our receptionist. Let them know that you're under an emergency, that you have a deadline, and you need to do an intake. Okay, 1 second. Let me check the chat and see if we have any questions. Okay, so I have one question about if service of the eviction is mailed, you have 21 days to request the hearing. The start date on that 21 days is going to be the date on the letter. So it's not based on when you receive the letter, it's the date actually written on the letter. And usually the date written on the letter is the same date they posted on the public index. So this isn't something I really talked about earlier, but when evictions are filed, those are publicly available. You can see those records, which is important to know, one, because if you're trying to apply for new rental assistance, you could potentially run into an issue where new apartments or landlords will look up your public record and they might not want to rent to someone if you have a lot of evictions. Unfortunately, when those are filed, they're on the public record. There's not a legal process to have those records sealed or destroyed. They're publicly available. Once it's filed, it will show up. Even if you win your case, they can still see one's been filed against you. Yes, let me switch back to the resources. Okay, so you can see a case was filed. It'll just be marked differently. So when the case has been resolved in your favor, you won at court, or if you come up with a settlement, they'll mark it that way. It'll say the case was settled, or it'll say found for defendant and case was dismissed. So those help. It makes it a little easier to get a new rental or a new landlord to lease to you because you can show you won that case. And if they're willing to talk to you, especially if it's an individual instead of a large organization, then you can explain the situation. Sometimes the problem is the landlord. There are some landlords that file frivolous evictions. They don't have a good reason to evict you. They might even try to evict you when you've paid on time every time and you have a lease that's not expired. You have every right to be there. You've done nothing wrong. That's possible. It does happen. It's a very unfortunate situation that you can't get that removed. It's going to be on the public index. So the reason I mention that is if you haven't done the declaration yet and it does apply to you, I would recommend doing it even if you haven't been served eviction paperwork yet, because they really shouldn't be filing once they have that because they're put on notice and it says they shouldn't go forward with an eviction. So if you've given them the declaration before they filed and they file, there's an argument that they're breaching that order and they shouldn't have done that. I unfortunately don't think you're going to be able to get it removed from the public index still. I've at least not been made aware of any court that's agreed to do that. or that they really should legally since they're required to keep those records. But you might have some kind of recourse against the landlord where they violated the CDC order because they went forward with an eviction and they didn't have any good reason around that. It might not work if it's one of those cases where they're not just saying you owe rent, they're saying you violated the lease because the CDC declaration didn't apply then. But if it's just a rental payment case, you gave them the declaration, they shouldn't have filed, at least until it expired. And if you've done the declaration before, you shouldn't have to do the new one, but it wouldn't hurt, especially if nothing's been filed yet, to go ahead and re-sign it using the CDC's new form. That way it says that it ends on January 31st, because then it makes it really clear that the landlord was put on notice and they shouldn't have gone through the eviction process. Unfortunately, it kind of varies which courts are communicating with the landlords. Some of them have told them that, okay, it's been extended, your case was continued again. Or, they make them aware of that maybe when they're trying to file, ask them, hey, has your tenant done a declaration? Have you received one yet? Is this a case for non-payment? They might go through that, but not every court's going to. Some of them weren't even telling landlords that the CDC declaration was extended. So they had hearings scheduled in January when they thought this was going to be expired, and they had to either go there or call in, and they were told at that time. They might not have been aware of it, especially if they're not doing their due diligence and following what's been going on with Congress lately, and they weren't aware of the addition in the stimulus package. Okay, I'm sorry. I see, I think there's another person trying to join, so I'll go ahead and let them in. Are there any other questions? I think I've covered all of them that I saw in the chat, but if anyone else has another question, feel free to ask at this time. Okay, now I will try to, at the very least, share the presentation. So if you need the resource slide or you just want to look through the slides to refresh your memory, if we're not able to get the recording posted online, I'll at least try to send that so that information is available. Like I said, if you're in this situation and the CDC declaration does apply to you, I do encourage everyone to go ahead and get every adult on your lease in your household to sign that declaration and deliver it to your landlord. That way you know it applies to you. And I would also keep a record of how and when you delivered it to your landlord, just in case they are going to go ahead and try to file when they shouldn't. If you can mail it to them, you normally do your payments by mail. Go ahead and keep a copy of it, mail it, and keep a tracking number to show when it was delivered. If you do it in person and hand deliver it, just keep a note of when you hand delivered it and who you gave it to. That way you have that in case it becomes an issue. I'm sorry, hold on, there's one more question here. Okay, if you're in a situation where your case has been continued and you receive rental assistance, it is important. I would recommend you go ahead and document it just in case your landlord still tries to argue you owe a balance or they try to proceed with the eviction, especially if your assistance is enough to pay the full balance you owe. Ideally, if they're getting it from an agency that's providing the assistance, some of them will send it directly to the landlord, and then you can get a copy of proof that that payment was submitted and when and how much from the provider of the funds. But if you're getting loans from family, friends, or other sources where they're giving you the money and then you have to pay your landlord directly, or if you've found a new job, you've received your stimulus package or your taxes come in and you're able to make payments toward your back rent, when you're giving the landlord payment, I would try to get them to sign a release or some kind of written acknowledgement that they've received that rent. If you communicate by text, if they acknowledge having received it in a text message, that's better than nothing. At the very least, keep a log of all payments you're making and when as you make them. That way you have a record of it, especially if you're doing cash payments, because you don't have any kind of receipt or accounting or tracking process for cash. So you need to keep a record, keep your own personal log. And if your landlord will sign a receipt, and hopefully they will, get them to sign a receipt. That way there's some acknowledgement from them when they received it and the amount. That can be very important, especially if you're able to pay it all back and they're going to try to argue you owed additional late fees or you were still behind, so they want to go ahead and evict despite you making those payments. And that's pretty important to keep in mind. especially since one of the things you're saying you're going to do under the CDC declaration is make your best efforts to pay what you can. That's one difficult situation. Unfortunately, I don't have a great answer for this, but you could be in a difficult spot where you're able to pay some, but not your full balance. Because if you can pay some, you really should, but you might need that money if you know you're not going to be able to reconcile with your landlord and you're needing to seek new housing arrangements. Obviously, you're going to have to make your new down payment or your first month's rent at any new place you rent from. There's not a great answer to that. Don't keep more than you would need for that. Pay what you literally can. Anything you know you can part with, you really should pay, or else they have the ability to argue you've committed perjury, and then you face those penalties. Or they could try to argue the court before the court, like motion to get before a judge before this ends, and convince them that the CDC declaration has not been followed, it doesn't apply to you, so they can get an eviction now instead of waiting till it expires. You just got to make your best efforts. Most courts aren't really going into those details. One, because quite frankly, their dockets are busy. There are a lot of these cases that have been filed. It's a difficult time for everyone, so they're trying not to dig into the weeds more than they have to, but there's always the potential your landlord can really push it, especially if they hire an attorney and they have an attorney making those arguments for them. It's going to be harder for the court not to at least humor it and give them the opportunity to present those arguments. That's why sometimes it might be nice to reach out to your landlord if you've already done the declaration, it's in the pending process. See if they're willing to do some kind of agreement in writing where you can make a payment plan. You're not paying maybe the full amount you owe, but before this expires, you agree to pay X amount over your normal rental responsibilities every month for a set number of months to get current. If you have that in writing and in that written agreement, they state, as long as you're making those payments on time, we will not proceed with an eviction for late payment during the CDC declaration, then you can show that to a judge. Then they should be bound by that agreement. They shouldn't be able to get an eviction for late payment then on that point in time. Of course, once this expires, if you fall behind again, the CDC declaration is not going to apply. The Landlord-Tenant Act will. And as long as they have the right notices in their lease or they send it to you, a judge is going to be kind of forced to eventually grant an eviction, or grant an eviction for the new late payment, not the balance that you had solved by an agreement. Okay, and I see a question here. If the full payment amount is made by January 31st and the lease ends the same day, what can be done with the landlord? Okay, what can be done if the landlord doesn't want to provide a new lease? That's always that's a difficult one too. So ideally, you would get some kind of written extension of your lease. Say, hey, I can pay the full amount. I can, I think I can get it together and pay it by January 31st. If you tell them that and say, I think I can do that. If I'm able to do that, would you agree to extend my lease term? You give me an additional 6 months or something like that. Whatever you can agree with your landlord, and they do a new lease, they extend it. You do an amendment to your lease. Then you can, have that as an agreement, make the payment, and have that new lease signed, or have the agreement that they will extend your lease and keep a written copy of that where they have signed it and acknowledged it. That way you can pay them the full amount and you don't have to worry about them taking the money on January 31st and then immediately the next day sending you a 30-day notice. Technically, they could do that. If you pay them the full amount, you get current. They might not be able to evict you for being late on your rent or failing to pay. But if your lease has expired or it's month to month, they can go ahead and send you the notice to terminate your lease. And then you'd only have 30 days. You just spent that money you got together, paid your full balance, and now you might be in a tight spot where you have to come up with that down payment and first month's rent for another property, and you only have 30 days to do that. That's why it's best to try to get an agreement with your landlord and get them to acknowledge it in writing. If you're in that situation, this is, like I said, it's a Band-Aid. It's not a perfect solution. It doesn't really help with those end of lease terms. And that's always a problem. When your lease ends, even if you've been the perfect tenant, if your landlord doesn't want to rent to you anymore, they don't want to rent to anyone. Maybe they just want to, renovate the house or building and sell it. They're allowed to do that, and they don't have to extend your lease. They could always do those 30-day notices, even to someone who's done nothing wrong but a perfect tenant. When your lease is about to expire, before the expiration date, they could send you a notice at least 30 days before that and say your lease is going to expire on this date. This is more than 30 days notice. Once that expiration happens, I'm not renewing your lease. And if they've done that, then if you haven't moved out, once that expiration occurs, they can file in a magistrate court and say that they're evicting you because end of lease term. And it's not really something you'd be able to defend at that point unless they, took money from you and you had some implicit agreement that they'd let you stay there longer. But you have to prove that, which is why it's always good to get things in writing, especially if you're giving them all the money you have to, get current and extend your lease. Try to get them to agree to that and try to get it in writing if that's your situation. Okay, any other questions? Okay, well, I hope this presentation helped today. And if you do have legal problems, eviction related, or if you have other civil legal issues, do feel free to apply if you think you qualify for our services. Like I said, we do a wide range of services. We help with some employment law issues. We help with probate. We do wills, advanced directives, power of attorney, healthcare, and financial. We do assistance with foreclosure proceedings as well. If you applied for Social Security and you need help appealing that, we do help with those cases as well. Those are some common issues that we do assist with. We do a wide range of civil legal issues. I mean, even expungements, that's the closest we get to criminal. We can't defend criminal cases against you. You need to talk to a public defender for that or hire a private criminal attorney. And we do have limits on personal injury type cases or malpractice. Those are usually fee generating. You can get paid out of the award you get if your case is successful. Usually they take those on what's known as a contingency basis, or statutes might give you attorney's fees where when you win, you're paid out of the reward you get from the court. The opposing party has to pay your fees. You only get that if a statute says you do. And in those cases, we might not be able to assist, or at the very least, you'll have to talk to a private attorney first. But if you think it's one of those areas, it's one of them I said we definitely do, and you financially qualify, go ahead and apply. We can always tell you if you're not going to qualify or if we need additional, attempts before we can represent you. We'll let you know if that is the case. Okay, well, thank you everyone for attending. Appreciate your time, and like I said, I hope this helped out.
Lori?
Yes, ma'am.
Oh, sounded like somebody was trying to say something. I don't know. Guess not. Good job.
Okay, well, I mean, if you receive any other questions from anyone after this, feel free to send me or Stephanie an email, and we'll answer any we can. Or if it's one where they have to apply, we'll give you that information on how to apply again. All right. Well.
Yeah.
Like I said,
thank you.
Thanks everyone for attending. I'm gonna go ahead and